Hi, I'm Mark Cunningham with Grace Property Management. We're looking at the series of 4 new regulations, 4 new laws that the Colorado legislature passed and Governor Polis signed into law recently. Last month we looked at the bedbug law. This month we want to look at the Rental Application Fairness Act, which is HB 191106, because the legislature looked at the rental industry and said, hey, we need to make sure landlords are not overcharging for rental application fees to help tenants out to apply. Makes sense, but it's a pretty complicated act. So we want to go through some guidance on how to ensure that you, as a landlord, whether you manage 1 unit, whether you own 1 unit, whether you own 50 units, it doesn't matter. This applies to you. So if you're a single landlord with 1 property, these rules apply to you just as much as they apply to us as a third-party property management company. And guidance number 1 says what it governs, and it governs rental application fees. And they have a very specific definition for those rental application fees. Anything that is non-refundable, anything like a pet fee, it applies to that as well, pet application fees. Anything pertaining to the application to apply to rent a property. It applies to holding fees as well. So that's what it applies to. And number 2, the application fee law limits the amount an application fee can be charged. And I'll tell you what that is in just a minute here. It also requires disclosure of what those fees are on the front end. That makes sense. And it requires a receipt for applications. Makes sense. All those things make perfect sense thus far, but it gets a little bit stickier. Guidance number 3 says this: the maximum amount that can be charged by a landlord to an applicant to apply for the property is the actual expense that the landlord incurs in processing the rental application, or it's the average expense the landlord incurs per prospective tenant in the course of processing multiple rental applications. That's a mouthful, but what that means is you can't charge your applicant more than it actually costs you as a landlord to process that rental application. And if you're doing a lot of rental applications, as we are, well, obviously everyone will be a little bit different, so you kind of take the average of what it costs you as the PM company or as the landlord to process a rental application. Now, how much does it cost? That's kind of hard to figure, because you've got things like you've got to go and pull a credit report. That's a hard cost, but you've got staff time of individuals calling landlord references. That's some time. So how do you factor what that is exactly? It's a little bit tricky and difficult to do, but you still have to do it. You also have to disclose that. So the application fee law also limits the information that be considered in evaluating an application. So here we're taking a big turn. We're saying, hey, landlords, you need to tell tenants how much you're going to be charging. But in addition to that, now landlords, there are certain things you can and cannot do while you are actually processing the application. We'll look at those in just a second here. But it requires specific action when applications are denied. So if we deny an application, we have to follow certain rules now and notifications back to the tenant. And it requires that you as a landlord refund. You have to refund any unused portion of the application fee. So let's pretend that you charge your applicant $50 as an application fee, which that's somewhat high, but somewhat average for Denver. You charge that application fee. And in the processing of the application, your hard costs were only $45. You then have to refund the additional $5 back to the applicant after the processing of the application. Administratively, that's a hassle, but it's the law. The landlord must provide every prospective tenant with a receipt for any application fee received, which that's good business. That's good practice. If you take the application fee, you need to give the tenant a receipt. It says an electronic receipt is okay unless the tenant wants a paper receipt. Now, why would a tenant want a paper receipt? I don't know. We're going a little back in time there with technology the way it is. Most things are online, but if the tenant wants a paper receipt, you as the landlord must give them a paper receipt for their application fee. Guidance number 6 is that the landlord is required to refund unused application fees. I just talked about that. And you've got 20 days. So 20 calendar days after you have processed the application, you have to refund any of those fees. Number 7, the rental and the credit history beyond 7 years, this is big, beyond 7 years may not be considered when making leasing decisions. Now this is new, and this is going to shake up our industry. What this means is we cannot look back beyond 7 years on an applicant to look at their credit history or their rental history to determine whether they're approved or declined. Potentially what that means is if somebody had an eviction 8 years ago, we can't take that into consideration. If somebody had terrible credit and owed a landlord a bunch of money 8 years ago, cannot take that into consideration. We used to be able to take it into consideration, but no longer. 7 years is the cap. Now, they also say this, arrest may not be considered when looking at a leasing decision, which that makes perfect sense, right? Innocent until proven guilty. Just because somebody was potentially arrested, you cannot take that into consideration when you're processing the rental application. But it gets more complicated as well. It also says this: the criminal history of that applicant beyond 5 years. We're only going back 5 years now. We can only look back 5 years of the criminal history of an applicant. Anything that happened prior to 5 years may not be taken into consideration when you're processing that application, except for a few specific things, and that's meth-related offenses, it's sex offender-related offenses, and it's homicide and stalking-related offenses. So if the applicant had a meth, sex offender registration, or homicide or stalking that was beyond 5 years, you can still take that into consideration. But anything else, 5 years is the cutoff. Now, I don't like this personally, because if you've got a dangerous individual coming in and you've got other people in that property, in a multifamily property, you kind of want to take that into consideration, but no more. What this says is beyond 5 years out, doesn't matter. You cannot take that into consideration in the processing of the applicant. Now, what we have to do upon that denial, if the landlord is denying that application, within 20 days, you must provide the prospective tenant a written notice of the denial. So you have to tell them in writing that they're denied, and you must state the reason for the denial. What is the reason that their application was denied? The law says this. It says if you use specific screening criteria that doesn't really tell you the specific reason, like let's just say they just didn't meet the score, they've got a score of 10 and they only scored an 8. So, what is the reason for that? How do you explain that? Well, then in that case, if you really don't have a specific reason for the denial, you have to give the tenant a copy of the response from the screening company that uses the proprietary screening software, and you're supposed to give them a copy of their report. Now, this is a little bit tricky because federally, legally, as it relates to national law, we can't do that. The feds say you may not give a copy of the tenant's credit report to anybody, including the tenant. It's a very restrictive law. They can get it from the screening company, but they can't get it from us as a PM company. So the law says in Colorado says we've got to give them a copy. Federal law says we can't give them a copy. That's going to be a tough one to figure out. We'll make sure they get a copy and we comply with federal and state law, but that's a tricky one there. Now, upon the denial, a landlord must within 20 days provide the prospective tenant with an electronic version of the denial notice, unless the prospective tenant requests a paper copy. Again, we have to give them a paper copy if they want it. Now, there's a lot of liability if you violate this Rental Fair Housing Act. So you want to make sure you don't violate this, property managers or real estate investors. The tenant, if they push back, they can get triple the amount of the rental application fee plus court costs and reasonable attorney fees if they decide to file a claim. The tenant is required to give 7 days notice before they file that suit. And if the landlord corrects or cures, then the landlord is not liable for damage. So you just want to make sure that you're operating within the confines of these laws. And as a real estate investor or as a property manager, you should be okay. One more aspect on this as it relates to liability of tenants now. The law also says that a person or an applicant who purposefully and in bad faith brings a meritless claim against a landlord is liable for the landlord's court costs and reasonable attorney fees in defending the claim. In other words, if a tenant applies and you just deny them, legitimately deny them, and you go through the process and the tenant just is mad because they got denied and so they sue, you're okay, Mr. Landlord, as long as you went through these things. If the claim was meritless, now how do you define if it was meritless or not? Well, the judge will have to do that. So this, practically speaking, will this bring some protection to tenants? I don't know. We haven't seen exorbitantly high application fees in Denver. This is going to keep that from happening, which I guess is a good thing. But we just need more supply. If we get more supply of units, landlords won't be able to charge exorbitant rental rates or rental application fees. If you've got questions on this, contact our office, Grace Property Management. We're happy to help you out. If you're one of our clients, don't worry. We're already abiding by these terms. We're keeping you protected as your property management company.